Quick note before we dive in. This is a real story based on public documents from the Rhode Island Department of Health and reporting from credible news outlets. This video is for educational and or information purposes only. I'm DK, and on this channel, we break down real-life estate planning and money stories in plain English so you can protect your family and your hard-earned money. In this episode, you'll learn how a caregiver ended up as a beneficiary on a patient's IRA and why that raised red flags, what the state of Rhode Island did about it, and the estate planning and boundary lessons you can take to your own attorney or advisor after this video. So here's the case. There's a licensed certified nursing assistant in Rhode Island, Christina DeFina, and the elderly home care patient is only referred in the documents as patient A. Christina works through the home healthcare agency called Visiting Angels of Rhode Island, and she was providing in home care to patient A. The patient's relying on this because they want to stay at home instead of going to a facility, and the relationship gets closer over time, almost like family. So we've established now that patient A has an individual retirement account or an IRA, and we don't know the dollar amount, but we do know that at some point, Christina allowed herself to be named as a beneficiary of their IRA while she was actively providing care, and she was being paid to care for this patient. So she permitted patient A to designate her as the beneficiary of this IRA. She also did something else with the medicine, which is quite interesting, but just becoming this temporary beneficiary because she says that this was only meant to be temporary as far as her being a beneficiary. That's what she told the regulators. What's interesting is that she also administered morphine to this patient, and we're going to talk more about that later. Regulators say this crossed a major professional boundary and created an improper financial relationship with the patient. So let me ask you at this point, have you ever checked on your IRA on a regular basis or your 401k or your life insurance to make sure that those all list exactly who you want to be beneficiaries? We all go through life changes. People get married, get divorced, they adopt children, they give birth to children, they get separated. All any of those life changes I listed could cause you to need to make a change in your beneficiaries. So it's always a good practice to check those. I would say once a year around your birthday, maybe make a note either a week before or a week after your birthday in your phone calendar. So reminders to check that. And if you do this on a regular basis, if you're checking those beneficiaries every year, put checked in the comments. And if you haven't, put need to check in the comments if you haven't been checking that on a regular basis. So let's talk about a couple of these decisions that were made that really raised red flags with the state of Rhode Island. The first one was the IRA beneficiary change. According to the consent order and the news coverage, Christina permitted patient A to designate her as a beneficiary on patient A's IRA while she was their paid caregiver. And later, she told them that the patient asked her to be a beneficiary. And then it was only supposed to be a temporary situation. So we're not in the room for this conversation. We don't know how much patient A knew about IRAs or whether anyone else in their family, their attorneys, their financial advisors knew that this change was being made. But from a legal and ethical standpoint, this is where red flags kind of start popping up here because this person's a paid caregiver and they could now possibly stand to inherit directly from a vulnerable patient. There's also a financial relationship that is possibly tied to this person's death because it's a beneficiary agreement. And then this is all happening while the caregiver is still actively providing care. It's not like Christina provided care, the patient was pleased, and they said, okay, she was previously my caregiver, so I now want to reward her in some way to be a beneficiary. This person was still actively providing care. And in some states, when a non relative caregiver suddenly becomes a major beneficiary, the law presumes undue influence and puts the burden on the caregiver to prove that the gift was fair and that the gift was voluntary. The second decision is that at the same time, they're saying that Christina administered morphine to this patient, and morphine is a controlled substance. And she did this on multiple occasions, according to the paperwork. And keep in mind, Christina is a nursing assistant. She's a CNA. So she's not licensed or trained to give a controlled substance like morphine to a patient. She told them she did this. She told the regulators that she did this because the patient was too weak to administer the morphine to themselves. So then you've got a whole other can of worms here. You've got a vulnerable, physically weak patient. You've got a paid caregiver who, once again, stands to benefit from this person's death if they're a beneficiary. And then that same caregiver is controlling access to strong medication. So even if everyone involved felt like what they were doing made sense in the moment, this combination is looking really risky from the outside to anyone looking, especially from the Board of Health at the state level. So here's a moment that we can all learn something. In many cases, courts and regulators look very closely at major financial gifts or beneficiary changes that are made when someone's elderly, they're sick, or heavily dependent on one person. If the caregiver or a person in a position of trust is receiving a benefit, that also makes the regulators look closely. And also if there's no neutral, independent advisor involved. So, based on just kind of making some inferences in this case, it seems like either financial advisor was not involved or maybe one became involved. And that's when the red flags went up. A lot of questions still in this case. Because when the regulators look at cases like this, they're going to ask questions. Things like, did the person truly understand what they were signing? Were they pressured or either subtly or overtly pressured into signing? And who benefits from this change the most? Is the person benefiting a longtime spouse, a dependent, or someone that's relatively new, like a caregiver that's, being paid to be there? So those kind of things raise questions. Okay, so let's look at what happened. At some point, someone raised a concern. What's interesting about this is there's not a lot of information. When you even look at the formal complaint, which I'm linking in the description, they don't give a lot of details as to who told them something was going on, who told them they might want to investigate, what's going on, where's the family. There's a lot of interesting questions. So it'd be interesting if any of you know anything about this, that any filling of the blanks, how this came to the road Island Department of Health's attention. We don't know who complained. It could have been another healthcare worker. It could have been someone at the home healthcare agency. It could have been a family member or either another professional who noticed something might be going on. But what we do know is the complaint reached the Rhode Island Department of Health and they opened that formal investigation. And what they ended up doing was a consent order with her. And that consent order lists a series of findings and fact. And in plain English, they concluded that Christina, and when I say they, that's the Rhode Island Department of Health, concluded that Christina was a licensed nursing assistant in Rhode Island. She was working for Visiting Angels of Rhode Island, caring for patient A. While doing that job, she allowed patient A to designate her as the beneficiary of patient A's IRA. She administered morphine to patient A multiple times, despite not being licensed or trained to do so. And from there, the Department of Health moved into more of a legal side of the analysis. And they concluded that Christina's conduct violated Rhode Island's nursing assistant laws and regulations, created a prohibited financial relationship with the patient, and they also concluded that her conduct is considered unprofessional conduct and it was detrimental to the patient's health and or patient safety. So here's where things get interesting. The punishment here was really surprising. Instead of going through a full contested hearing, Christina and the Department of Health entered into a consent order. And basically, it's an agreement that sets out the findings of their investigation and it details the punishment. The consent order is in lieu of any administrative hearings, and as part of the agreement, Christina waives her right to appeal the consent order. So here's some key findings on that consent order. Christina's is going to be suspended for 6 months. So her nursing assistant license is suspended for 6 months. During that 6 months, she can't practice as a CNA at all. Before she can even ask to get her license back, she has to complete two specific courses. One is on the personal care of patients for CNAs and HHAs, and the second one is called Professional Boundaries for the CNA. And the course titles alone tell you how the regulators view this. It's not just a technical issue, but it's a boundary problem that the regulators saw. After that 6 month suspension, if Christina meets the conditions and completes those two courses, and at that point, things don't quite go back to normal. There's going to be a 1 year probation period where she can possibly start working again. And for at least that 1 year, she can only work as a nursing assistant in a hospital or a nursing facility under direct supervision. She may not work as a CNA in private homes or anywhere without direct supervision. Her license status is going to be marked as administrative and active until a hospital or facility confirms in writing that they employ or tend to employ her. And then, if they do so, then her license status becomes active probation. If she changes jobs during probation, she has to report the new employer to the department within 2 weeks, and her employers have to send quarterly performance reports to the Department of Health. The consent order also notes that this disciplinary action will be part of her permanent record and can be reported to national databases that track healthcare disciplines. So even though we don't have a courtroom scene where there are family members yelling at each other and or yelling at the caretaker, the consequences are still pretty interesting here because Christina's career took a hit here. Her ability to work one on one in private homes is restricted, at least at this time. And a lot of CNAs often work in more of the private home setting. So that's an impact there. And then her name is publicly attached to this case in official documents. I'm going to be honest. When we look at these cases, a lot of times you can get background information and kind of fill in the blanks. There are a ton of questions here. You can notice there's a lot that's not in the documents. We're not told whether patient A died. We're not told whether Christina ever actually received money from the IRA. Was there any kind of distribution? Because if there was, and that could definitely have triggered, people to say, wait a minute, why is there a distribution and why is it going to this person? We're not told whether the family did or did not challenge anything in probate court. And if there is families around, how did they even find out? If patient A is still alive, is Christina's name still listed as a beneficiary on the IRA or in the IRA? And then, there's so many other questions. So let me ask you, if you found out that a paid caregiver had been added as a beneficiary on your loved one's IRA, what would you do? Drop down in the comments, put challenge if you'd immediately question that, or comment talk if you start by asking calm questions and gathering facts, because everyone's personalities are different. Maybe you want more information, or maybe you kind of go straight to, hey, no, let's investigate. And I don't want to ask any questions, just let the authorities investigate. So let me know, drop down either challenge or talk in the comments. I'd love to see how you'd handle this situation. So, what lessons can we take here? There's actually a few. First are that beneficiary forms are estate planning. Patient A, um, whether they had a full trust or not, you didn't have to even go through all that paperwork for there to be a problem. Just changing the beneficiary on the IRA, especially someone that's a non-family caregiver, that was enough to trigger a regulatory investigation. So you want to always make sure that your wills, trust, and your beneficiary designations all work together. In most cases, when things are contested, a lot of times they look at that beneficiary form very closely, when they're trying to decide, what decisions to make. So if your beneficiary forms don't match what you think your estate plan says, your actual estate plan might be a different story. So you want everything to match. That's our first lesson. Second lesson, professional boundaries are legal boundaries. The regulators didn't just say this looks bad, they cited specific Rhode Island laws and the nursing assistant regulations. And the statute in Rhode Island prohibits conduct inconsistent with patient health and safety. And there are also rules in some places that state that nursing assistants can't engage in certain financial relationships with patients. So, in other words, for a licensed caregiver, it's not just a question of, is this nice or did the patient mean well? The question you need to ask yourself as a caregiver, is this allowed at all under my license and under my state's rules? Third lesson we learn is caregivers as beneficiaries can be a legal hot zone. Across the US, many states treat big gifts or inheritances to caregivers as automatically raising some type of red flags. Some states create a legal presumption of undue influence when the non relative caregiver suddenly becomes a major heir, and other states make it easier for family members to challenge those gifts in court. So even if everyone feels like the gift is fair, the law may say, this is too risky. So we're going to assume something was off unless you can prove otherwise, that unless you can prove that nothing was off here. And our last lesson, lesson number 4, clear planning is key before anyone ever has a health crisis. If patient A has a clear written estate plan set up long before needing home health care, and if those documents were being reviewed regularly, there'll be less room for last minute changes that confuse everyone. I'm not saying you need a specific document, but that's for you and your own legal professionals and financial professionals to decide. But this case shows why. If you wait until you're sick or dependent to make major changes, that creates suspicion. So you really want to have everything set up front. Also, bringing a caregiver into your beneficiary list late in life can trigger both legal and licensing problems. And you want to check those plans and documents again regularly. Once again, like I said, check your beneficiaries once a year around a week or two before or after your birthday. Just set a phone reminder in your cell phone just to make sure that any changes that are made are changes that you approve of. Because once again, if let's say everything's perfect the way you want, you may at that time remember there's a change coming up, and maybe you need to make a change for something that you know that's coming before your next birthday. You're at your current birthday, so it's always good to check these things in a timely manner. Okay, so next steps and questions to ask. So at this point, here's a few questions you could ask yourself, and then take these questions to a legal or financial professional. First question, who would be legally in charge if I became incapacitated tomorrow? Is that clear on paper? And does that person know what's expected of them? I can tell you that power of attorney documents normally will help with this. My series is coming up this month where I'll break down the 5 critical documents. So be sure to check that out. But that's the first question. Who's legally going to be in charge if I became incapacitated tomorrow? And remember, incapacitation has nothing to do with age. You could become incapacitated as a child, as a young adult, as a college student. These things need to be in place. We also have videos on who needs estate plans. So check those out to kind of determine what you may need in your personal situation. Second question, are my will, any trust, and all of my beneficiary forms telling the same story? As I spoke about earlier, you want to make everything speak together, and you need to know, does everything tell the same story? Or will your IRA, 401k, and life insurance go to someone completely different than your other estate planning paperwork suggests? So, does one set of papers say one thing and the other set say another thing? Because once again, then you're getting the courts involved. That's money, it's confusion. Everything should flow together and should match up. The third question, if I rely on a caregiver, especially a non family caregiver, how can I set up my plan so there are clear boundaries and no confusion later? Should the gifts to that caregiver be handled while I'm alive with documentation? Do we need additional protections if the caregiver becomes very involved in my finances or decisions? So just kind of think about how you want to set that up if you do plan to give a caregiver some type of provisions. And you need to know what your state's laws are about this and what rules govern that. And for caregivers, any caregivers watching this, what does my license or employer's policy say about accepting gifts, money, or being named in wills and beneficiary forms? Ask your supervisor, your professional board, your state board of health, or even your own attorney as a caregiver before you say yes to something that could cost you your career. And again, she said this was supposed to be temporary, which is really interesting because temporary in what sense? They put you down temporarily to be the beneficiary in order to do what? So, like, so that's it just opens up more questions. Of course, that probably raised more red flags when you said it was yes, but it was supposed to be temporary because it's like temporary for what purpose? And we don't have that information at this time. So take a second and write down the one question that stood out to you. Again, first one was who would legally be in charge if I became incapacitated tomorrow? The second one are my will, any trust, and all of my beneficiary forms telling the same story. The third question, if I rely on a caregiver, especially a non family caregiver, how can I set up my plan so there are clear boundaries and no confusion later? And the fourth one for paid caregivers or non family caregivers, what does my license or employer's policy say about accepting gifts, money, or being named in wills and beneficiary forms? And again, if you're interested, the consent order from the Rhode Island Department of Health is linked down in the description. And if you enjoyed any part of this video, would you hit like and subscribe for me? Thank you kindly. And check out this next video that YouTube thinks you'll like. Until next time.